Good morning all. We're here for a pre-trial review in the matter CFI-20-2015 before the Deputy Chief Justice Sir David Steele. The claimant is represented by Every's Legal Consultancy. Lead counsel is David Reid QC, assisting is Bill Gambro. The defendants are represented by Clyde & Co. Lead counsel is James Brocklebank QC, assisting is Mark Beswetherick.
Good morning. Thank you. I think I've done my homework, but I regret to say I'm missing one item which we haven't been able to dig out of the file, and that is the draft trial timetable. If you have a spare copy, please have it.
I think there's a spare copy in the PTR bundle that's been filed with the court. I believe it's at tab 7 of that bundle. PTR bundle 1.
What do you call the PTR bundle? Bundle 1. Okay. Yeah.
Yes. It's behind.
Which?
I think that's tab 8, I'm grateful. Yes, behind our checklist for the pre-trial review at tab 8, at the back of that, there is a spreadsheet.
Thank you, I've got that now. I had the checklist, but not this document. Right, thank you very much.
Your Honour, just to correct one matter on the record, it's David Head, not David Reid. You may be aware of that. My friend Mr. Brocklebank appears on behalf of the defendant.
Yes.
I'm pleased to be able to say, Your Honour, that we hope not to detain you for very long today, and notwithstanding a fair number of agenda items, that there is broad agreement on most of those items, so I will take you through them relatively quickly. Subject to your views, I intend to proceed in the order appearing in my skeleton argument, just because I can. The first thing, so I'll start, Your Honour, at page 5 under the heading Matters Arising. I don't intend to talk to you more generally about the detail of the case or the background and so forth. Firstly, just to update the court on progress generally, the news is all good, I think. There have been some delays and slippage, but not very much. Importantly, all evidence and supplementary evidence has now been served.
Including the Sharia law? Including
the supplementary Sharia law reports. That took place, I think, either Sunday or Monday. So we're all done so far as evidence.
So just on that topic, the supplementary reports recently exchanged on Sharia law, are they in the reading bundles, the modest reading bundles I've been asked to read in apparently 2 days?
The answer is no, Your Honour. They will be added so that your 2 days reading more compressed.
I think my copies are about to be sent to London by courier, so if either immediately after this hearing, if copies could be given to the registry so they could put them in the bundles. If not, perhaps it could be emailed to me direct.
Yes, of course.
One or the other. Okay.
Very well.
Thank you.
Well, apparently we've got them here, so we'll attend to it.
Well, that's ideal. Okay. So if before we leave this morning, perhaps you could make sure I got my hands on those 2 documents.
Will do.
Thank you.
Certainly. You're on a trial bundles. Again, the news is broadly good. The bulk of the bundles has been prepared. They were due to be prepared and circulated on Sunday of this week. As you know, there have been some delays in providing suggested inserts from the other side. I don't want to dwell on that, but suffice to say that we're pleased to say that suggested inserts have now been provided. We're in the process of dealing with those and making sure that they're inserted in the bundle. That's all in hand. We anticipate that the final version of the trial bundles will be completed as of tomorrow, close of play tomorrow. No doubt there will be further insertions between now and the start of trial, but we're in pretty good shape.
Now, that's on the basis, is it, that the spreadsheets, whatever they may be,
Yes.
Are going to be in electronic form?
That's right. Again, I think there's broad agreement on that. The problem was that because there are so many spreadsheets attached to emails, attached to reports and so forth, that if you include them in the hard copy bundle, that boosts the bundle up to something over 100 files. So we're going to provide them by way of electronic bundle. We've just been having a discussion in court before Your Honour came in as to how that will be handled. Apparently those spreadsheets will be available on the electronic screens here. There will be an operator in court.
Okay, so if the number is called, it will come up on the screen?
Exactly so.
Okay.
I mentioned in my skeleton, Your Honour, that the parties will need to just address formally the question of authenticity and hearsay matters in the usual way. I don't anticipate there's any difficulty in relation to that, and we'll deal with it between the parties. I'm happy to say that on the question of referencing, in other words, amending references on witness statements and expert reports, it's agreed that the parties will reference their own witness statements. That's in the process of taking place, and again, I understand that'll be finalised within the next day or two. Now, there is a question about, if you like, a wider electronic version of the bundle. This is relevant, as you may have picked up, particularly in relation to the evidence of Mr. Hubbard. Now, you'll obviously hear that application in a moment, but assuming Mr. Hubbard does give evidence by video link from California, as you know, Your Honour, my client, one of my clients, is giving evidence from Geneva by way of video link. Our intention in relation to him is to provide a hard copy bundle in Geneva, rather old school. We fully understand that carting an entire trial bundle over to California is quite an exercise. And we've certainly indicated that we're prepared to cooperate in any way to prepare an electronic bundle if we can. It's not entirely clear to us how big an exercise that is at the moment. We've got lots of documents in electronic form, but collating that in a single chronological run, for example, might be more difficult. What I have indicated after discussion with Mr. Brocklebank is that we're entirely happy to provide an indication of what documents we will not need to put to Mr. Hubbard. So, for example, it is very unlikely that Mr. Hubbard is going to deal with matters of Sharia law. It is very unlikely that Mr. Hubbard is going to deal with IPO valuation or anything of that sort. So substantial swathes of the bundle will not need to be available to Mr. Hubbard. What is probably going to have to happen is that the chronological bundle, the ordinary chronological bundle, which itself is quite substantial, will need to be available to him. Now whether that happens by way of physical files or whether we can cooperate with each other to prepare an electronic version of the chronological bundle remains to be seen, but one way or another we will sort that out.
Well, it will need to be sorted out a bit. I mean, there's going to have to be somebody there to operate the electronic bundle, isn't there?
Yes.
Yes. And if, for some reason, a question needs to be asked in regard to a document that's not in the electronic bundle, i.e. not available to him in electronic form, some consideration needs to be given to how that might be shown to him. I mean, in a sense, one possibility is that I fully understand that you don't want to produce what might be called a cross-examination file, that I understand. But it must be possible to identify which bundles you are likely to refer to.
Yes, that may be right.
Yeah. Okay, well, I leave that to you. It seems to me you're approaching it very sensibly. Well, we'll have to deal with the mechanics of having a video link 11 hours behind in a moment,
Yes, that's much time back to
which
that.
presents its own problems.
Yes.
And at the moment, as I understand it, no decision is to be made as to where Mr. Hubbard will actually be. Was that right, Mr. Bobman?
Your Honour, I think there is an update to that. My sister's been working hard to try and make a venue, and he's actually, at the time when he'd be giving evidence, he's actually staying in a hotel which has conference facilities.
Oh, right.
So he would be able to
That may work well. Okay.
We're in the process of...
Well, it's quite important to check it too.
That's exactly what we're doing, Your Honour.
Yeah.
We'll obviously liaise with Mr. Head's instructing solicitors to make sure that everybody's happy.
Right, well, let's cross our fingers on that a little bit. Yes.
Very well.
Okay.
Let's move on, Your Honour.
Well, the only other item in regard to the documentation is a core bundle, which I regard as rather important in a case where there are 60 or 100 files.
Yes, I think both parties are alive to the fact that a core bundle is going to be absolutely critical in this case.
Yeah, okay.
So I think all I can tell the court at the moment is that we will give anxious regard to that and work hard to make sure that that the parties cooperate to produce a helpful and concise
I regard that
bundle.
as particularly important. Okay.
Understood.
Your Honour, I apologise, Mr. Just on the subject of the core bundle, there are a couple of documents in the case which are important, which are quite lengthy, including the report, which is at the heart of the case.
Right.
Would Your Honour find it helpful to have that in the core bundle? Or would you
Well, I'd like to avoid putting large documents in the core bundle.
Yes.
Well, I fully understand that the report is obviously going to play a significant role
Yes.
in the case. I think I'd probably like that separately bundled,
Yes.
frankly.
Yes.
And what was the other big document that you had?
Well, there's the CRSD proceeding. I think that in total there's a 2 voluminous to go to a court.
Right.
But there are things
Well,
like...
this is a transcript of it.
It's a judgment.
As a judgment.
But it's a very lengthy judgment because it sets out an extenso of the parties' submissions.
Well,
But that's in a separate bundle already.
maybe they need to be. I don't know whether they can go in one bundle.
Yes,
That
they
perhaps
have
seems a
their
more
own.
sensible course.
Yes.
Okay. But not in the core, no.
No. And otherwise, as Mr. Head says, we will try to be as sensible as we can with the
Thank you.
the core bundle.
Grateful. Yes, Your Honour, both the report itself, the report at the heart of the case, is in its own separate bundle. It is
anyway.
It is anyway.
Okay.
It and its appendices.
But what about the judgment? Is it
The CRSD proceedings, including the judgment and the extensive appendices attached to that, are also in a separate bundle.
Okay.
So that I don't think much point
we need to
dragging them
know
into a
about
court.
that. Okay, thank you.
Next item, Your Honour, amendments. Again, I don't think I need to trouble you with that. We have made some amendments to the particulars of claim, in large part simply to make sure that the pleadings align with the expert evidence that's now been served. There is a consent order in the bundle, PTR bundle, tab 3. I don't need to take you to it. Where consent is given to those amendments. It's agreed between the parties. I had thought that the amended defence was going to be served on the 18th of April. I see that the consent order actually refers to the 19th of April. That's fine by us. We have indicated that once that is received, very shortly thereafter, we will endeavour to serve a very much shorter version of the reply. As Your Honour will recall, the reply originally served was before we had seen the report. And much of the reply is now redundant. So we intend to serve within a day or two or three of receiving the amended defence a very much more streamlined version of the reply.
Thank you.
Your Honour did mention the question of summaries of the pleadings. Those do exist, Your Honour. I don't think they were in the court bundle last time
I
around.
didn't see them. Okay.
They are there. Again, no doubt both parties will have a look to see if there any tweaks need to be made to those in order to reflect the latest version of the pleadings, but that will be attended to. So I think I can move on unless Your Honour has any further comments on that. Skeleton arguments for trial. The original CMC order was a little bit ambiguous just because of the rules about which days do and don't count for the purposes of calculating time periods. Subject to the court's views. It is now agreed between the parties, and I've spoken to Brocklebank just before court. It is agreed between the parties that we will serve our written opening on Sunday the 29th of April, and that the defendant will serve its written opening on Tuesday the 1st of May.
Okay.
Hopefully that gives Your Honour plenty of time to consider those before the start of trial. As Your Honour knows, there's a 75-page limit on those. That should be ample to tell Your Honour about the case. Video link, Your Honour, as I mentioned, my own client is giving evidence from Geneva via video link. I mentioned that briefly. One, to inform Your Honour that there is a technical test taking place later today, as I understand it. The facility that he's giving evidence from, Nedicom in Geneva, apparently has very high-tech equipment, but we're testing to make sure that that is so. We assume that will all be successful. One potential issue which impacts on the trial timetable, which we'll discuss in a moment, is that facility is not available on a Sunday.
So even if he was available, we couldn't start him the day it's proposed to openings. That's the point, is it?
That's the point. Now, that may or may not impact on the length of time that Your Honour wants to hear from us as advocates by way of opening on the Sunday. We don't suggest that we simply filibuster to use that time. However, Your Honour will have his own views as to how much he wants to hear from us. But what time is not used by way of opening on that Sunday will
Let
not.
me just say the time difference with Geneva is 2 hours or 3 hours.
I think it's 2 hours at this time of year. Yes.
2 hours.
Yes.
So that, for the sake of example, if we were otherwise sitting from 10 till 5 or something, that would be
8 until 3.
8 till 3.
Yes.
Yes. And this is before Ramadan, at least, so that doesn't affect his position.
That's right.
Well, so what do you, there's a bit of a dispute as to how much time should be spent on the factual witnesses, but assume for present purposes this Mr. Al Mojil gives evidence for a day and a half.
Yes.
Starting on Monday the 7th and finishing midday on the Tuesday. When are you suggesting we should sit?
During his evidence?
Yes.
Well,
should we start later and finish later, or not?
I'm not asking for that, Your Honour.
Okay,
I'm perfectly happy for him to sit.
Reasonably flexible. I mean, this place is open at 8 o'clock in the morning, is it?
It is open at 8 o'clock in the morning. So Mr. Oliver has just indicated he'll be sitting with Mr. Al Mojil, perfectly happy to sit at 8 o'clock in the morning to accommodate ordinary court hours here.
Right. Okay. Well, then, for the moment, we have to come back to this point, but we'll start Mr. Adel Al Mojil at 10 a.m. Dubai time on Monday, finishing his evidence at 1 p.m. on the Tuesday.
Yes.
Okay?
Thank you. Now, as you know, Your Honour, Mr. Brocklebank has an application to make in relation to Mr. Hubbard, so I'll let him make that application.
Thank you, Mr. Brocklebank.
Your Honour, thank you. I should start with an apology to the court and to the claimant that Mr. Hubbard is not able to attend in person. We accept an unfortunate mistake that's happened as to the period of the trial. I have made inquiries as to what happened, and to be quite honest with Your Honour, it's somewhat obscure as to how the mistake arose. But it did, and the situation we are now in is that Mr. Hubbard is not available to travel here during the period of the trial.
Right.
He's not my client's employee, he's not in my client's control. So The reality appears to be, from conversations with Mr. Hubbard, that if there isn't a video there...
And where is he, in fact, San Francisco?
It's going to be in the San Francisco area, the west coast of the United States, yes.
But you think he is staying in a hotel that has video facilities in it?
I'm told that he is, and tests are going to be conducted.
Well, there's no, what I call objection in principle to Mr. Hubbard giving his evidence by video. I think the only real potential problem is the time difference, which is quite demanding, isn't it?
Yes, it could certainly be more convenient, Your Honour. And we've proposed, and I understand Mr. Head is not objecting, that he should give evidence in the Dubai morning, which would be late in...
So he would give evidence sort of 9:30 at night, you mean?
That's right, and he is content, well, content is perhaps the wrong word, Your Honour, but he is prepared to do that. What we've proposed is that if we started, subject to Your Honour of course, but if we started earlier, for example 8:30 Dubai time, that would be 9:30,
right.
Mr. Hubbard is in the evening.
Right.
And if we continued then for 3 hours, for example, that would take into midnight.
Yes.
And subject to Your Honour, I think Mr. Head is the principal content to accommodate that, for which we're very...
Well, we'll come back to this topic when we're looking at the timetable generally.
Yes.
But that's really the only way it works, is it?
It is, I'm afraid, Your Honour, because the afternoon for us is very early in the morning for Mr. Hubbard. And I think even with his willingness to cooperate to this extent, that would probably push the limits of his cooperation. So yes, that appears to be the option. Plainly, it would be possible to have shorter sessions and have him give evidence more than once, but I understand that his preference is to endure a later finish and be done on one occasion rather than have to attend twice.
So 3 hours would finish at 12:30 San Francisco time?
Yes.
Okay, thank you. Well, I'm subject to reviewing this in the context of the overall timetable.
Yes.
You have leave to call Mr. Hubbard by way of a video link, but I want an assurance that appropriate technical tests have been undertaken.
Yes.
To ensure that we don't have a breakdown.
Yes.
Or at least should avoid a breakdown.
Yes.
And that if and to the extent he needs assistance with either an electronic bundle or bundles generally,
yes.
There is somebody in the room with him who should be identified to me. And that also there is a technical man from the hotel who is available in the room.
Yes.
In case we do have a breakdown.
Yes, well, we will certainly make those arrangements. Right. There is a Claimco office, I think, in San Francisco, correct? And somebody from that office will be able to assist with bundles and the like.
Thank you very much.
Thank you, Your Honour. We've made the point in the skeleton, Your Honour, that it does seem to us that in circumstances where the need for Mr. Hubbard to give video evidence arises out of either his fault or certainly fault on the defendant's side, that the costs of the facilities, as well as the costs, any additional costs by way of furnishing an electronic trial bundle or similar, ought to be met by the defendant rather than by the parties jointly.
Well, Your Honour, I suggest, I would submit it's not sensible in separate order in respect of these costs. They're not going to be a significant part of the overall costs, and the reality is there would have been costs associated with him attending here in any event, which would have been costs in the case.
Well, I'm not going to make an order at the moment, but I think the point is quite well made.
I understand.
And we can come back to it when we need to consider costs. Okay?
Yes, I think perhaps just some clarity on that point. Your Honour, I see that it might be open to argument in due course as to who should finally meet those costs, but certainly they should be met in the first instance by the defendant.
Well, I don't know to what extent, if money is needed up front, clients are going to have to put the money up front anyway, aren't they?
Well, I would have thought so.
Yeah.
I don't think there could be any issue about that.
Very well.
Right, now, trial timetable.
Trial timetable. Now, again, Your Honour, I think there's a measure of sensible agreement between the parties on a number of these points. The first point is the question of oral openings on the Sunday. Now,
well, in a way, the point is already made. I will benefit from some degree of oral opening, and usually I would expect 2 or 3 hours from the claimant and perhaps an hour or so from the defendant. But here, how much time is spent on it in that first day is irrelevant, because Mr. Al Mojil is not available until the Monday. As presently advised, I would allocate the morning to the claimant and the afternoon, to the extent needed, to the defendant. I would expect to be rising early.
Well, Mr. Brocklebank has heard you up.
Right. Okay.
Now, so far as overall timing of factual witnesses is concerned, Your Honour, our draft timetable was only that. Our best guess as of 2 or 3 weeks ago.
Yes,
now, I acknowledge that I may well be shorter with individual witnesses than this timetable contemplates. That is the case in relation to Mr. Hubbard. I'll come back to him in a moment. Almost certainly less than a day. Mr. Cassie, almost certainly less than a day. Mr. Pubalor, probably less than a day. Mr. Iqbal, probably less than a day. And as for Mr. Ardawal and Mr. Alex, certainly less than a day between them, probably less than half a day between them.
So I see you put Ramadan on the 16th, is that right? I thought it was the 17th.
Yes, so this is out of date.
I don't quite know how it moves about.
It does move about. Certainly when I checked a couple of days ago, it is currently estimated to be on the 17th.
Yes.
I'm not sure whether that is now final, or whether that's still might move around. In any event, Your Honour, so far as overall timing is concerned, I hope to be done with the defendant's factual witnesses by close of play on the 14th. I understand from Mr. Brocklebank from his helpful indications that it's not suggested that there should be any sort of guillotine on the 14th. I recognise that if I go beyond the 14th, then Your Honour is going to be looking anxiously at the timetable and wondering why. But it is possible that we will go into the 15th for those factual witnesses.
Well, I will say no more for the moment than I would expect, in any event, the factual evidence to have finished sometime on the 15th.
Understood.
If it finishes earlier, so much the better.
Very well. Now, just dealing with the question of Mr. Hubbard in this context.
Yes.
Subject to the court, of course, and no doubt it'll involve matters of court staff availability as well as Your Honour's own availability. But we're certainly happy to sit from 8:30 on Thursday the 10th.
And that would give you really 3 hours.
Yes. Now, I've said that I'm going to be less than a day with Mr. Hubbard. Whether I can be done in 3 hours with Mr. Hubbard, I think is open to question. Now, I understand that his preference would be to get done in one day. He's indicated that he could also be available on Sunday the 13th. So if there were some overrun, he could come back for a second session. It's also possible, I guess, that he would prefer to be there until perhaps 1:30 in the morning, San Francisco time, if it meant that we had 4 hours straight through with him on Thursday the 10th. Now, if that's his preference, I suspect that 4 hours will be enough to deal with him. So that may be the best for all concerned. But
well, the moment. Mr. Brocklebank, do you want to make any observation?
The only thing I was going to say, Your Honour, is that given that helpful indication from Mr. Head, we will go back to Mr. Hubbard and find out whether he would be prepared to sit later.
Right. Well, I think 4 hours is absolute maximum on that,
yes.
At that evening for him.
Yes.
If for any reason there's some good ground for saying that we should draw stumps at 12:30 or 12 o'clock, then we will sit at 8:30 on the 13th.
Very good.
But in any event, the total number of hours will not exceed 4 hours.
Understood.
Is that all right?
Yes, I'm not sure I'm suggesting a guillotine of 4 hours, Your Honour.
Well, I am, I think.
Yes, I heard that. Very well. I'm reasonably confident that that's sufficient, so I'm not going to.
I think 4 hours is enough.
Very well.
Okay? Thank you.
Now,
Well done. Thank you very much for all that.
yes, I think that does deal with it. As I've indicated in the skeleton, it obviously makes sense for the defendant to have its next witnesses available so that everything can be dragged forward a little bit as necessary.
Actually, I just need to check that the staff will be here at 8:30 a.m. or 8 o'clock more accurately. You couldn't ask Aisha to come in, could you? Could you ask Aisha to come in? Okay. I suspect it's fine. Indeed, they all seem to be here whatever hour I arrive. Okay.
Well, we'll perhaps come back to that and assume that's okay for the time being.
Yeah.
Length of court sitting days, Your Honour. No one's suggesting, we're not suggesting that the court should announce in advance that we're going to sit long days every day.
Okay. Well, I'm happy with that. I'm prepared to be as flexible as the parties require within reason. I had indicated I was prepared to sit long hours. That was because of concern about whether 3 weeks was enough. At the moment, I'm not concerned that 3 weeks is inadequate. I would anticipate sitting probably what might be called normal court hours, 10 till 5. If somebody wants to start an hour early the next day, or wants to sit late to finish a witness, I will.
Very well.
So I think it's better to be as flexible as possible. I would be very reluctant to start, say for special circumstances, before 9 o'clock, and I'd be reluctant to go on past 6 o'clock. But I suspect that gives you sufficient flexibility to manage the witness evidence.
I think it does.
Okay.
As you know, Your Honour, I mean, we do think that the timetable is quite compressed.
Okay.
There are a lot of witnesses to get through,
Well,
but I
thank you
think
very
with
much.
that flexibility...
Well, it's very, very helpful by the parties. Aisha, on Thursday the 10th of May, there's a witness who's going to be in the west coast of the US. And in order to get his evidence, we need to establish a video link at 8:30 in the morning. And we all sit until lunchtime. So it means some staff will have to be here by at least 8. Is that okay? You start at 8 anyway. I should never have asked. How embarrassing. Right.
Who knew what activity went on behind the scenes?
Well, there you are. You've heard that. So that arrangement with Mr. Adel on Thursday the 10th will work, and if necessary on Sunday the 13th.
Well, we're very grateful.
I mean, the fact there is a 2-day gap makes it all the more desirable, if it's possible, to finish Mr. Hubbard on the Thursday.
Yes.
Okay? Thank you.
You're not, I've mentioned Ramadan at the skeleton, just to inform the court of the latest developments.
Yeah.
It's on the 17th now. What that means in terms of any sort of practical arrangements, clearly some witnesses are going to be impacted by that.
So there will be some witnesses who are fasting, is that right?
Yes.
I mean, leaving aside what I call the legal requirement in a public place
Yes.
to fast, there will be those who are fasting as a matter of religious requirement. Or is that, I mean, who, for instance, in the list?
Well, I think it is likely that both Saudi law experts will be fasting.
Right. So that's Mr.
Al-Khamis and Mr.
Al-Khamis and Mr. Al-Sawaf.
Yes. I think they're the only ones directly affected.
That strikes me as right. Let me just deal with them as a special case, but Ramadan starting on the 17th, so effectively it coincides with the expert evidence.
Yes.
Yeah. I think it's not possible in open court to have, I don't know, glasses of water around or anything like that. That's obviously a problem. But I think we would need to allow for the comfort of witnesses, counsel, spectators, and perhaps most importantly of all the transcribers, that they should have a break from time to time to be able to go and have a drink if they feel they want one, yes. Or have some lunch if they feel they should. I'm anxious not to have a whole series of adjournments for 5 minutes because they turn into 15 minutes within a flash. We would have a natural break in any event in an ordinary trial in the course mid-morning and mid-afternoon for the transcribers. I think I must rely on counsel to tell me whether they feel that another break is needed during the course of the morning or the afternoon, in which case I will arrange for, say, 2 breaks, one at, say, I don't know, 11 o'clock, one at 12 o'clock, and then one at 3 o'clock and one at 4 o'clock. But it will be a short break, okay? So for the moment, we will have a standard break mid-morning and mid-afternoon at some convenient moment.
Yes.
And that will give an opportunity for anybody to go elsewhere as wanted. Now, are there any well, you probably don't know the answer, any requirements for break for prayers at any of these witnesses?
Apparently not.
Well, that's good. Okay.
Your Honour, I don't know as far as we're concerned. We will check, but we haven't been alerted to any.
Yes. Well, if you would alert me in due course if a point arises.
Yes.
So, okay. Well, there's not much more I can do with Ramadan.
No, well, that's, if I may say respectfully, Your Honour, that seems like a very sensible way to deal with it. We will. It'll obviously, in part, depend on whether we are sitting longer hours and so forth. So we'll just deal with that as we go along.
Okay.
Closing submissions, Your Honour, the vexed question. Your Honour knows, when we discussed this last time, broadly speaking, the court was in favour of...
Well, I was in favour of it for 2 reasons. Firstly, because I would actually need some help.
Yes.
And if I push people to do their closing submissions during the course of the hearing, there's very little opportunity for preparing material, let alone in writing.
Yes.
And I would benefit from written closing submissions, which I read and then can have short oral hearings in which, in effect, for my benefit, I can ask questions. And it had the added bonus, it seems to me, that would likely to afford a bit more extra time within the 3-week period. So the answer is yes, I do want the written submissions and I do want the oral submissions, and I fully understand it's not entirely easy to find a space for it.
No, quite. I mean, just so you know...
So where are you now?
Well, we have suggested, Your Honour, a relatively short break, in other words, a break of about a week. When we finish the evidence on Thursday the 24th, we've suggested that we come back a week later with written submissions, or just over 8 days later with written submissions by Friday the 1st of June, with oral submissions the following week, either on the Monday and Tuesday or the Tuesday and Wednesday. Now, that creates difficulties for Mr. Brocklebank's side. Specifically, it's not Mr. Brocklebank's own difficulty.
Well, not a difficulty with preparing them, but a difficulty of having an oral hearing immediately after it.
Well, I don't. I'll let him explain his difficulties.
Your Honour, it is both.
Both. Well, because of the trial on the 3rd of June.
The position is this, Your Honour. It's not, as Mr. Hitt said, it's not my availability. My junior has closing submissions in writing, I should say. It's not a hearing, but she has deferred them in another case in order to do this case, and those are due, I think, on the 8th of June. And so, all things being equal, she is committed to do that in the period where Mr. Head would have us preparing our written closings and then attending before Your Honour to do oral closings. and plainly she
So let me understand the dates then. I know you suggest written submission by the 21st of June.
Yes.
But your junior is not available in the week of the 4th of June, so it becomes available on the
The 8th.
13th, correct?
No, after the 8th, Your Honour. But
Okay. So that's why you're asking for the 21st?
yes, Your Honour, because plainly I'll be relying heavily on my junior to assist me with the preparation of the written closings in particular. The oral closings then need to follow a reasonable time afterwards. I understand that there are difficulties then on the claimant's side, because Mr. Head's junior is getting married in the middle of June, and Mr. Head himself has a commitment, which I understand is a 3-week trial starting at the beginning of July. It's possible, subject to Mr. Head's trial finishing on time, that we might be able to come back at the end of July to do oral closings. This, of course, is all subject to Your Honour's own...
And that's, I confess, difficult for me.
Yes.
I've got a heavy commitment to the second half of July and the first week of August. My present availability is really the first 2 weeks of June and the first 2 weeks of July. So there's anything you can do to around that.
Well, Your Honour, I'm going to be in trial for the first 2 weeks of July.
I see that. Yeah.
So the early part of June is fine for us.
But not fine for them.
Not fine for them. I simply don't know. In part, of course, it will depend on the length of time that Mr. Brockbank's Jr. is going to be engaged with closing submissions. I mean, if I don't know, for example, whether it would be possible for her to complete submissions in this case in the 4 or 5 or 6 days or 7 days after the conclusion of the evidence in this case, if that was a deadline imposed on all of us before turning then to her submissions in the other case, and then we can all come back, at least leading counsel.
Yes, help me with that, Mr. Brockbank. You tell me that, sorry, Mr. Head, Mr. Reed tells me that he understood that your junior had professional commitments in the week of the 4th of June. Is that inaccurate?
Well, it's not inaccurate, but the professional commitments don't start on the 4th of June, if I can put it that way.
So he's got to prepare something before the 4th of June, is that the point?
No, the deadline for the preparation, as I understand it, is the 8th of June.
Right.
But
so there is time between the end of the trial and the 4th of June?
No, Your Honour, I'm sorry.
I'm misunderstanding.
I'm not being clear. There's no magic to the 4th of June. Nothing is happening on the 4th of June. After this hearing finishes, my junior is straight away committed to be involved in preparing closings in another case that runs up to the 8th of June.
Right.
So at the moment, that's the position. Now, plainly, we can investigate further whether there's any means of adapting that. But as I understand it, it's a commitment which has been deferred already on more than one occasion to accommodate this hearing, which is why there are difficulties seeking to defer it further.
Your Honour, obviously I'm keen not to put Mr. Brockbank in unnecessary difficulties, but I do have to point out that this was a trial with an estimate of 3 to 4 weeks.
Yeah, that was the point I was about to make myself, that she wasn't going to be available for that anyway.
No, exactly. So the parties ought to have available until the period up until the 31st of May. But by virtue of the original listing of this case. Now, I appreciate if one's working on another heavy case and with lengthy closing submissions to write, one would prefer plenty of time to do that. But what I'm proposing is that both parties get their written submissions done, in this case, within a week of the close of evidence, even if that does mean that Mr. Brockbanks Jr. has to either compress the work or seek a further short extension to complete submissions in another case. And thereafter the parties are able to come back perhaps in the second week of June when her submissions in the other case will be complete, and before my junior goes off to get married, to have oral closings. Now, I appreciate that that's not a timetable he's comfortable with, but that might be the most workable solution all round.
Your Honour, can I say two things? One is, let us investigate further whether we can do something about the...
I have to say, whether it assists the parties or not, the reality is, given Mr. Head's commitments in early July, the only real opportunity for a hearing of, say, 2 days is probably the second week of June. So we've got to try and aim for that.
I hear you.
Okay?
I hear what you want to say.
And now this trial ends on the 24th of May. I think it must be possible to put together a timetable for preparing written submissions. I can't give you a date for when I could come out in mid-June, but let's say sometime around the 13th of June. I'm not quite sure. I haven't got my diary on me, but
yes,
that's what we're looking at. So we've got to fish it in that period.
Yes, Your Honour, I hear what you want to say, and we will make that work.
Okay.
Can I just say one thing in defence of my junior? She was available for the original 3 to 4 week listing, but then at the January CMC, Your Honour indicated it was only going to be 3
I
weeks.
should never say things are not needed. Right. Okay.
I know she'd want me just to point out.
But I mean, it isn't actually entirely clear to me. She's got to prepare submissions for another case.
Yes.
Quite what the timetable of that case is, or whether there's a hearing immediately she finishes the submissions, or whether it's just the provision of written documents.
I think it's...
Anyway, it needs some further inquiry.
Yes.
I'm afraid I can't hold this trial up for her convenience. Okay?
I understand, Your Honour.
Right. So we're going to leave that, if we may. We can raise it again during the trial, or at the beginning of the trial, or at the end of the trial.
Yes.
It's the sort of point that very often would be dealt with at the end of the trial. But for the moment, there really is only one window of opportunity. Okay.
Well, with that in mind, Your Honour, I think with respect, it does make sense for the parties to address it in the next week or two, so that we
Well, it better tie this down.
Yeah.
I agree. Yeah.
Rather than simply leaving it to the first day or two of trial, because
Okay.
I think we all need to know where we stand as far as that is.
Thank you very much.
Yes, Your Honour, what is the best way for us to verify your availability?
Well, I need to get my diary.
Yes. We can do it.
Just give me a moment. I'll go and get it.
There's a possibility of the Eid holiday.
Sometime before it.
We don't know yet.
No, wait until before we're there. Here. It's fine.
2 days.
Oh yeah, the move was
Yeah, fine.
Is there a current?
Not quite as simple as I thought. As I say, I think I've rather misremembered the content of my diary.
In case it assists, Your Honour, I'm not sure it will. On present estimates, the Eid holiday, we think, is going to fall on the 14th and 15th of June.
Okay. Well, I've been looking at my diary. I have a whole series of problems. The reality is that the dates you mentioned in your own skeleton for all closings, 5, 6, 7 June, are available, but I'm now, having looked at my diary, much more pressed. As from, I thought I was free. I can't do the following week. I can do 5, 6, 7, 8 June, which is roughly what you were originally proposing, it is fair to say.
Yes.
I'm sorry that that is very, very limiting on the parties. If that's, I mean, of course, cases settled. July is not possible, I understand that. I then run into August. I could, I can't believe anybody would be enthusiastic, do time between the 12th of August and the 12th and 18th of August. Those are the only dates I can offer.
It's one I have difficulties in August.
Well, I fully understand that. Well, there we are. I'm afraid you're going to have to go away and chew the cud on this. I'm afraid it's going to have to be 5, 6, 7, 8 June. The 8th is and the 8th is a Friday, so that's no good. 5, 6, 7. Okay, well, I'm very sorry. My commitments are rather substantial at the moment. Quite apart from writing judgments and awards, but that's a different matter.
Well, Your Honour,
we are going to have to go away and try and cobble together a programme that we can sit on, say, the 6th and 7th of June,
yes,
each party being allowed a day to address me. If you feel that between you can manage with just half a day each, then that might make it slightly easier, I don't know. But I'm happy, I'm content to, but I never knows how many questions I have.
I think we both think that we'll need a
See what you can do, could you? Thank you very much.
We will. Thank you for the indication.
Yeah. Well, I'm very sorry not to have identified that problem a little bit earlier. Thank you very much. Is that it?
I think that's all the business that needs to be dealt with today.
Thank you.
Thank you for your
Can
patience.
I just remind you, you're going to let me have the Sharia law supplement,
The supplementary.
supplementaries.
Yes.
On that, I will see you on whatever it is.
Yeah, 6th of
6th of May.
Yes.
Thank you very much.
Thank you.